On March 9, 2026, in the courtroom of Judge Shelia Johnson at the 36th District Court in Detroit, Michigan, Defendant Dwayne Diehl appeared for a pretrial conference on criminal charges involving sexually explicit material. What began as a routine status hearing devolved into a tense confrontation spanning nearly 7 months of delays, with the court expressing mounting frustration over the defendant's repeated failure to review video evidence that could potentially exonerate him. The hearing would take an unexpected turn when the prosecutor raised serious questions about whether Diehl was even competent to stand trial, setting up a dramatic clash between defense strategy, prosecutorial patience, and judicial authority.
Dwayne Diehl.
Good morning, Your Honor. Courtney Rosenhoff again.
Hey, good morning, Judge. Like Baldwin, P6541, on behalf of Mr. Diehl, who's coming in the court.
Okay, so I hope y'all watch the video.
Good morning.
Mr. Diehl. All right, so we are back.
Yes, Judge, and Mr. Diehl and I sat in that conference room next door, and it was eventful. It was productive. The simplest, easiest way to let the court know what we're doing is he and I are going to work in collaboration. I'm going to file a motion. That's the direction that we're going to go.
Alrighty.
That's where we're at. And everything else that may or may not have transpired since the last court date, we have an accord. And I have an understanding as to what my client's expectations are.
Mm-hmm.
And I'm going to attempt to exceed those expectations with a motion to the court.
So let me ask you a question. When we adjourned, there was a possibility of polygraph potentially, and there was a picking a date to watch the video at the prosecutor's office. Did any of that occur?
Yeah, it was scheduled, but
Watching the video or the polygraph?
But I want to make sure that I hold my client high regard. I saw the video. I was at the polygraph. It was my client's decision. I don't want to make sure that it's the polygraph's off the table.
Okay.
We made those efforts.
But what about, he made such a stink, and I'm bringing it up. He made such a stink here, and I know you've repaired that, but I'm not a part of that. So I'm bringing it up. You make such a stink about it, Mr. Diehl, that you wanted to see the video. I mean, I don't care if you do the polygraph. You have a right to say, no, I don't want to do that. But what happened to watching the video? You were the main one wanted to see it. He just said it was scheduled.
So here's what I had offered. We got the polygraph set up. You had to move quickly because the polygraph guy is very busy.
I'm sure.
On the schedule, by way of explanation, I want to make sure I'm not pointing any disparaging fingers. I let my client know that we could back to back the video at the same time at 3 o'clock and have the polygraph at 4 o'clock. I went to watch the video and I went to the polygraph, and we were ready, willing, and able to proceed, and that's where it is. I watched the video.
Yes, Your Honor. Mr. Baldwin and I met at my office. We did review the videos together. He indicated to me that Mr. Diehl was given the opportunity to attend this meeting to watch the videos,
Okay.
but that he.
Hey, if he's happy, if he like it, I love it. Don't tell something. No, I don't even want to know, Mr. Diehl. You want it? I don't really care. I just want to make sure that we don't hear nothing else about it. Nobody showed you the video. That's all I'm concerned about. No, that's not a problem. I'm not doing nothing else about that.
The court is attempting to determine whether the defendant actually reviewed video evidence that could be crucial to his defense, while the defendant, through his attorney, pivots toward filing a motion rather than engaging with the evidence review process that has been repeatedly scheduled since August 2025. Under Michigan Court Rule 6.201, defendants in felony cases are entitled to discovery of evidence the prosecution intends to use, including the right to inspect and copy tangible evidence. However, when dealing with sexually explicit material involving adults, courts impose strict chain of custody and viewing restrictions under MCL 750.145C and related evidentiary rules, requiring defendants to review such materials at designated secure locations rather than receiving copies. The prosecutor's offer of a polygraph examination represents a common prosecutorial discretion tool. Polygraphs are generally inadmissible at trial under Michigan's version of the Frye Standard, People v. Barbara, 1987, but prosecutors may use them as investigative tools to evaluate whether charges should be dismissed pre-trial. Here, the defendant has repeatedly demanded to see the video evidence, his right under discovery rules, yet has failed to appear for scheduled viewings since August 2025, now 7 months prior. The court's frustration stems from this pattern. Diehl insists on seeing evidence that could potentially exonerate him. The video allegedly shows he did not commit the charged acts, yet avoids the very process that would make that possible. The prosecutor's polygraph offer appears designed to shortcut the prosecution entirely. Pass the polygraph, and the case disappears. But Diehl's refusal to engage with either the video review or the polygraph creates the going in circles dynamic Judge Johnson identifies. This exchange illustrates a critical tension in criminal defense. Defendants have absolute rights to review evidence, but exercising those rights requires actual participation in the process. Courts cannot force defendants to engage with their own defense, yet prolonged refusal to review potentially exculpatory evidence, while simultaneously demanding case resolution, can erode judicial patience and prosecutorial willingness to negotiate. For viewers, this demonstrates how procedural rights become meaningless without defendant cooperation, and how even strong legal positions can collapse when parties refuse to engage with the mechanisms designed to protect them.
If he wants to do something with you,
Yeah.
then he can do that.
Let's do this, Judge.
But let me say this. Let me just say this. Everybody in these criminal matters is busy. He's busy. The prosecutor's busy. The polygraph guy's busy. He's real busy because I'm sure he's running around doing polygraphs all over the county and whatever. So the bottom line is, if you got something scheduled, you gotta kind of go. Now, if you choose not to go, that's one thing. That's fine. You don't have to go to polygraph. That was an option. But if he's saying you were supposed to watch the video after, why don't you just go to the video and forget the polygraph?
You never made that thing.
What library?
It was the same thing.
The South Hill Library, remember at one time we ran that we could schedule.
You want to be more relaxed. What does that mean?
Well, Your Honor, the videos were never going to be shown in a public library.
Yeah, I was going to say, considering the nature of the things, they don't even release it. That's why you got to go up to their
My
office.
client is trying to say,
It wasn't a video, it was to go around discovery, to find out where we were at and everything, in a calm setting, where I didn't feel.
Well, sir, you can't do that. You got to watch the video at the prosecutor's office. That you have to. Now, you could go to the library with your lawyer after. You know what, Mr. Diehl? I don't understand. This is the easiest thing in the world. I'm confused. And I don't understand why I'm confused. It's the easiest thing in the world is to just make a date and go. What's the problem? We've been talking about this for literally months now. And every time you come, you never have watched the video. It sounds like a scam, like you don't really want to watch it, but you delaying for some reason.
Your Honor, may I?
What is it? Yes.
It's become more and more evident to me through my dealings with Mr. Baldwin, and he has argued very strongly on behalf of his client.
I see.
But I've become aware that Mr. Diehl is demanding that he file a motion regarding a question of fact. I see that Mr. Diehl doesn't want to proceed to trial, does not want to continue on with this case, but also does not want to take the steps necessary, like a polygraph, to show the prosecution that we have charged him in the wrong. It has become more evident to me as we proceeded that Mr. Diehl is likely in need of a competency. I'm requesting at this time a forensic evaluation of Mr. Diehl. He does not seem to understand the charges against him or the court process.
Mr. Baldwin, you want to weigh in on that request? Because something's going on.
And I recognize that Mr. Baldwin is between a rock and a hard place between his client's wishes
Sure.
and what he and I have discussed.
I am comfortable with working with Mr. Diehl. I think he has made requests to me that seem to be fair and reasonable. What I would suggest.
Well, why are we going in circles then? That's what she's saying.
Yeah.
She's thinking, well, he's not understanding
Let's
something.
move it towards the motion. Let's try that. let's try to move that in the motion, get a motion drafted. Let's see how we do. You're right. You're absolutely correct, Judge.
Because I'm tired of it. And I'm supposed to, be here for him, be here for the prosecutor, and I'm here, and I don't even understand why we're not making any headway. That's the problem.
Let's try the motion. Because he and I are in full agreement to work together with the motion. There's no contention, unlike some of the other situations, planning. In fact, on the 19th of March, I've already asked Mr. Diehl to have a structured phone meeting with me at 11 a.m. to go over the preliminaries of the motion that I've put together as far as a work product before filing, so that he can have a voice.
Okay.
And Your Honor, I would object to adjourning again for a motion. As the court is well aware, this has been ongoing since August,
Well,
and we do seem to be going in circles.
what do you mean adjourn again for a month? That's the first time I've been asked about a motion.
Well, I would object to another adjournment, given the.
Well, how can he do a motion?
Your Honor, I don't believe that a motion is, and we can disagree about this, is backed by sound law.
I don't know what the motion,
also have-
you always want me to cut off the defense's ability to do something before I even know what it is they're doing.
I would agree with the court that it seems like a delay tactic, and I would refer to the court to the language that we went over in a different case, being Michigan Court Rule 6.125C1. On a showing that the defendant may be incompetent to stand trial, the court must order the defendant to undergo an examination by a certified or licensed examiner. I'm requesting that. I believe
What's the showing?
the showing, Your Honor, is what we have all witnessed as this case has gone on since
Oh,
August.
that don't mean
That
he's
defendant does not seem to understand.
incompetent. It means that he could be playing a game with this. That's what I'm getting. Do you have any history of hospitalizations?
I'd like to speak on my behalf.
Okay, hold on. Before we get into all of that, I'm looking at my first notes, which was August of 2025. We're going into spring in a week or two of 2026. We adjourned it for discovery August the 4th. Defense counsel had paper and needed to review video. This is when this started, August the 4th. The prosecutor's office, due to the nature of the pornographic material involved. That was August 4th.
Yes, Your Honor.
Mr. Diehl, yeah, I'm gonna let you talk in a second. I want you to hear how ridiculous this sounds. So from August to March, you have been unable to get anywhere to watch a video that is evidence against you. Now, let me just say this. You have to watch the video. You wanted to watch the video. You have a right to see the video because it's evidence against you, part of your discovery package. As long as your lawyer sees the video, we're good. Because at least the lawyer knows what it is and could prepare an adequate defense surrounding it, even if you don't see it. There's been talk and allegations about did you do it? Did you didn't do it? I haven't been privy to those talks. I just understood that was the reason why, possibly the polygraph. I don't know who requested that. Maybe they did. Say, hey, just show us. We'll dismiss. You have a right to change your mind or not take it. I don't have a problem with any of that. My problem is we go from August the 4th to September the 10th, adjourn pretrial to what? Look at the chain of custody of the video or whatever, get phone records, and look at photos, including video. Then we go to October the 8th. We're then looking at an expert to look at authenticity. They wouldn't even appoint that. But the lawyer did do that, tried to get it. And also to what? Review the discovery with counsel at the prosecutor's office, which is the video, prior to the next court date. That's October 8th. November 24th. Well, we're going to Thanksgiving now. So we left summer and we're in Thanksgiving now. The expert was denied. Defendant didn't go to view the video, but counsel saw the video. This sounds really like what we're saying today. Adjourned for counsel to receive some evidence that the defendant supposedly gave the police about the materials that he believes is exculpatory, but they didn't have before they charged him. Okay, adjourned for that. But coming up on Christmas, you done wore the first lawyer out. Attorney Shreeman withdrew as counsel. Then we had to refer to MIDC to get you new counsel, Mr. Baldwin, who's very patient. He got more patience than I do. So then we adjourned it to January 9th. Coming into the new year. And we'd have gone through Christmas, New Year's Eve, New Year. Here we go. We're adjourned for counsel to try to mend the relationship between you two and what? To review the discovery, including the video. Coming up on Valentine's Day now, 2/2 of 26. You mended the relationship. I was ecstatic about that because I do think you got a good lawyer. There is a possibility of the polygraph. Okay. It could result in a dismissal. Parties are going to pick a date to review the videos at the prosecutor's office. Here we are, March 9th. Coming up on St. Patrick's Day. The same thing. We haven't reviewed the video. We had a date for it. And we had a date for the polygraph, which I understand. So if you don't want to do that, you could have gone to watch the video. And no, you can't do that in a comfortable location where you don't feel intimidated. You can't. They don't even release, we're talking about child sexually explicit material. So you can shake your head all you want. Okay, adult. Sorry. That's misstatement on my behalf. Still bad though. Adult sexually explicit material. They don't, any explicit sexual material, they don't disseminate like that, Mr. Diehl. You gotta go watch it. They don't even give it to your lawyer. He can't get it and give it to you to watch together. That's why you gotta go there. So if you want to see what it is that they claim to have against you, you gotta go. But here we go again. Now, that's nothing to do with the motion. He's gonna do the motion, whatever that is. But I'm gonna tell you, right now, there's a 50-50 chance you lose this motion or you win the motion. We stuck with a trial if you lose. Okay, so I don't know if what she's saying is right, but whether you want to or not, the only way this case could have gotten dismissed would have been the prosecutor, in their discretion, dismisses it. They say we need to know if he allegedly did this, and we need a polygraph. Short of you doing a polygraph, it's not going anywhere. So we got to move.
The prosecutor has formally requested a competency evaluation of the defendant, arguing that Diehl's 7-month pattern of refusing to review evidence while demanding case resolution demonstrates he does not seem to understand the charges against him or the court process. Competency to stand trial is governed by Michigan Court Rule 6.125, which requires a defendant to possess sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against him, the Dusky v. United States 1960 standard adopted nationwide. Under MCR 612(1) Sue 5 to C1, the court must order a forensic examination when reasonable grounds exist to doubt the defendant's competency. The rule creates a low threshold. The court need not find incompetency probable, only that reasonable grounds exist to investigate it. Importantly, competency is assessed at the time of trial, not at the time of the alleged offense, and is distinct from the insanity defense or criminal responsibility, People v. Merle, 2009. Prosecutor Rosenoff's request hinges on Diehl's seemingly irrational behavior, demanding to see exculpatory evidence, being given repeated opportunities to do so, then refusing while simultaneously insisting the case resolve in his favor. This pattern could indicate either strategic manipulation or genuine cognitive inability to connect actions to consequences. Judge Johnson initially resists the competency framing, suggesting Diehl could be playing a game with this, which highlights the critical distinction between voluntary non-cooperation and genuine incompetency. The defense attorney's response is telling. He acknowledges something that's going on and that he's between a rock and a hard place, suggesting he too recognizes his client's behavior may not be fully rational, yet stops short of endorsing the competency evaluation. Competency evaluations are double-edged swords that can fundamentally alter case trajectory. If Diehl is found incompetent, proceedings halt entirely while he undergoes restoration treatment, potentially for months or years under Michigan's Civil Commitment Framework, MCL 330.2024 et seq. This creates a paradox. A defendant avoiding engagement with his case may find himself institutionalized longer than any criminal sentence would have required. For viewers, this illustrates how mental capacity intersects with criminal procedure in unexpected ways, and why courts must distinguish between defendants who won't participate rationally and those who can't. The prosecutor's strategic use of a competency motion also demonstrates how procedural mechanisms designed to protect defendants can be weaponized when their behavior frustrates the opposing party.
On. I'm not going to be doing this in August of 2026 because it'll be a whole year of watching the video. This case needs to be done. We need to go to the hearing here and deal with it. So I don't know what to tell you, but you can't get around the trial. I don't know what kind of motion this is, but if it's a loser, you can't get around the trial. If it's a winner, maybe you do. I don't even know what it is yet. And I sure haven't seen it because he hasn't written it yet. But I'm saying you got to get your head on straight. This is not going anywhere. And we can't keep delaying it. You see what I'm saying? You know, and you just got to let the process work through itself. And if you're not guilty, which you are right now because no one has proven anything, but you know what I mean, down the road, if you're not guilty, it's going to come out. You got to have faith in the system. It works 99% of the time. Sometimes it doesn't. People do get wrongfully convicted. But we can't just keep adjourning. Now, I'm going to let him do what he needs to do legally. And Mr. Baldwin is not known for filing specious motions. So he better not come up here with some motion that has absolutely no substance.
And Your Honor, I'd ask for an offer from defense counsel regarding the substance of this motion. Will be adjourned for that purpose.
What kind of motion is it? I'd like to know.
Your Honor, we're looking at ascertaining evidence on the video
Okay.
on the phone of it's not
Been done.
provided. And he and I are going to discuss.
So you haven't really.
I'm going to roll up my sleeves and I'm going to dig into the file and I'm going to make a good faith effort. He's asked me for a motion since the first day I met him. He's always asked for a motion. So
Okay.
I think, you know.
Now, let me say this. Mr. Baldwin will do his job. He will see if there's an issue. What if he comes back and he looks at the law and he can't file it because he has to file it in good faith. Every time you sign something as a lawyer or even as a regular person and you present it to the court, you are making a certification that you did a good faith effort in researching this, and it is well grounded in law or in fact or in the arguable, reasonable argument to change the law. Basically, if it's not that, he can't file it for you. And don't get mad at him Because he has rules too. You know, lawyers lose their licenses for doing silly things that they know better. But there's nothing wrong with him investigating an issue. But I've seen it plenty of times in criminal cases. The lawyer said, we're filing this motion. They come back and say, Judge, no, we didn't file it. There wasn't anything there. So it could happen that way. But you know, you had a good person that's going to dig in and look. But if he can't find anything to file, then we're ready for trial. Yes, sir.
We hear such time other than Mr. Baldwin this last time and the prosecutor's office in Onion. No one else had. They say they did, but they had no proof, no letter, no email, no voicemail. No
I understood. That was your issue.
Video. You know, we know that the video was in the property of Oakland County Prosecutor's Department in Pontiac. I was always aware of that. I never had a problem with that. But my attorney at the time said he had to.
I don't know if he had it on his laptop.
I never seen it. Between change of attorneys and change of places. I never seen it. So I never got disturbed before ever. If you regularly, when we sit down and he called me and said, hey, I'm busy, I can't see you today. Hey, I understand. As far as hiding something or playing a game, I dare not play a game with the courts and as the law stalling, I'm not delaying. All I want is my constitutional rights. That's it.
Well, we're here to give you those.
As far as the prosecutor saying that she thinks I'm incompetent, I am not. I'm absolutely very competent. I know exactly what I'm saying. I'm responsible for every word that comes out of my mouth. You want to waste your money, words competent, whatever you want to do, you feel free to do. I'm very competent.
Okay, so here we go. So-
We have what I believe to be a tentative date in April. I
Mr.
understand,
Baldwin and
but
I
it's
discussed
on
the
my
court
calendar. I need to get it on. If that's the direction that it's going.
Yeah, well, it's definitely going to trial unless something you file makes it not go.
Can we take the date off the 21st of April?
You don't want a trial date for April 20th?
The motion that Mr. Baldwin has described, I don't understand how that's not a question of fact. Obviously, if there's some sort of exculpatory material on a phone, that's going to be brought up in front of the trier of fact, and that's a question of fact. It's not a valid reason for a motion. Secondly, I refer the court to MCL 330.2020, section 1. A defendant to a criminal charge shall be presumed competent to stand trial. He shall be determined incompetent to stand trial only if he is incapable because of his mental condition, of understanding the nature and object of the proceedings against him, or of assisting in his defense in a rational manner. The court shall determine the capacity of a defendant to assist in his defense by his ability to perform the tasks reasonably necessary for him to perform in the preparation of his defense and during his trial. Your Honor, you have yourself mentioned he needs to get his head on straight. He does not seem to understand the nature and object of the proceedings against him. This is not about his comfort zone. This is about a criminal proceeding that we have continued with these adjournments for his benefit. The request that he is making of Mr. Baldwin and my position is that those are not rational. I'm still asking the court to order that competency. If the court is unwilling to order the forensic evaluation, my third point is that I would like a date certain for the trial, whether it be jury. If Mr. Diehl wants to waive the jury, that's fine, but I would like a calendar date for the trial in this matter, given that this has been ongoing since August.
No, you're going to get that.
Thank you, Your Honor.
So here's the thing. I need to have some showing that, other than the fact that it appears we've been going for months trying to watch the video, I need to have a showing that he just is incapable. Mr. Baldwin says he understands him, that he's assisting him in preparing this motion. I don't know the full extent of what the motion is, so I'm not competent to even say it's a ridiculous reason for a motion. I can't say that. So I don't know how the prosecutor can say that because it's not fully developed yet. I know Mr. Baldwin will not file it if there's nothing there. If it's a reasonable argument to be made, then he can file it. Sir, where are we right now? This room. What's the role of this woman right here? She's a prosecutor.
Do her job.
And she does that by trying to prosecute under the law. And your job as the client is to consult with him.
So can resolve this issue.
I don't see him. Yeah, he's done better than many people.
Judge,
Describing a civics lesson here. I can't say he's incompetent or potentially incompetent, so no, that request is denied.
can we move that April 21st date to a final pretrial date? I'll have the motion filed and press it.
How long do you think you're gonna take to,
Start moving on it this week. I have a meeting with him on the 19th.
why can't we use the 21st as a motion hearing date?
Yes, please. Yes.
So that would be,
Judge, can we,
no, do we don't have enough time for that?
the jury trial day, do you want to use that for a motion?
Oh, it's a jury trial. No,
So the court will be available April 22nd.
okay, so let's go.
Yes. Yes.
April
That
20,
will be the motion date.
okay,
And it will be properly filed in accordance with the court rules to ensure that the prosecutor has, ample notification.
motion to like suppress maybe? I don't know what it is, but I'm just gonna sort of call it that.
Filed that Judge Johnson will.
I don't know if we need witnesses. I don't know what's gonna happen. I don't even know what the motion
I
is.
still don't really understand the basis for the motion. So
I don't
can't
either.
speak as to my response.
I can't tell you either.
9:30.
Okay. All right, so let's do this. If we're gonna hear it on the 22nd of April. Let's see, we're at March the 9th now. Could you get it filed by March the 25th? That's 2 weeks and 2 days.
Oh, yes, March 25th, file by. Yes.
The judge firmly established deadlines for the case's conclusion while explaining to the defendant that his attorney cannot simply file any motion requested. There must be a good faith legal basis. The prosecutor renewed her competency concerns, citing the statutory presumption of competence and arguing the defendant's requests are irrational. The judge ultimately rejected the competency motion, but established a framework for resolving the case. Under Michigan Court Rule 3.3, attorneys have an affirmative duty of candor toward the tribunal, which prohibits presenting false evidence or making frivolous legal arguments. This duty is reinforced by MCR 2.114, which requires that every pleading, motion, or other paper filed with the court be signed by an attorney certifying that it is not interposed for any improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation, and that the claims, defenses, and other legal contentions therein are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law. Violations can result in sanctions under MCR 2114D, including monetary penalties and referral to the Attorney Grievance Commission. Judge Johnson explicitly referenced these certification requirements when explaining why Mr. Baldwin might investigate the defendant's requested motion but ultimately declined to file it. The judge emphasized that attorneys lose their licenses for doing silly things that they know better, directly invoking the disciplinary consequences of Rule 3.3 and 2.14 violations. This explains the tension in the courtroom. The defendant wants his attorney to pursue a particular legal strategy, but the attorney is professionally and ethically bound to assess whether that strategy has any legal merit before filing anything with the court. This exchange reveals a critical but often misunderstood aspect of the attorney-client relationship. Defendants frequently believe their lawyer must do whatever they request, but attorneys are actually officers of the court first, with independent ethical obligations that can override client demands. This safeguards the integrity of the judicial system by preventing courts from being flooded with baseless motions designed to delay proceedings. For viewers, this illustrates why "my lawyer won't do what I want" doesn't necessarily mean inadequate representation. It may mean the lawyer is properly fulfilling their professional duties.
Your Honor, if I'm able to get my response filed within a week from receiving the motion, can we keep the jury trial date for April 21st?
Wait a minute, I'm confused. Let me get my dates here. March 25th. See, I wrote the wrong thing. March 25th. So then you want to do
I'm requesting
a week.
a week to respond to the motion.
All
The
right,
motion hearing date possibly on April 3rd, 6th, or 8th. whatever.
I don't get a chance to look at it at all. I look at my motions before I actually hear them.
Of course, Your Honor. It's your discretion, of course. The reason for my request is that, as I've discussed with you previously off the record, the May jury trial date is a date that I won't be available personally.
We talked about that.
Yeah.
Jessica and I did. We might be able to switch them.
Oh, okay. Then that would work. Thank you.
Remember that, Jessica?
Yeah.
Okay, so if you just want a week then,
If we're gonna have a trial date in May, then I would ask for the full 2 weeks to respond.
okay, because I'll give you to April, and then that gives me 2 weeks. May I please have a judge's copy
Yes,
delivered to chambers?
yes, sir.
Because, and the response too, if you could, because they get stuck downstairs a couple of
No,
days.
no problem at all.
Yeah,
Paper and deliver?
yeah, paper,
Okay.
because we don't do e-file yet. It's coming.
Yes, Judge.
Thank you, Judge, and I'll provide the same. I appreciate you,
Yeah, there's no pre-trial.
giving me those dates. Am I to assume that it's 2 weeks from the time I receive the motion or April 8th? Because sometimes I don't believe Mr. Baldwin will do this, but there have been other cases where attorneys file things later than they say they will, and then I'm left with a few days to respond by the date given by the court.
I'll follow exactly what the court has.
You want me to do it in the order so somebody could get held in contempt if they missed a date?
Sure.
No, Your Honor. No.
Okay.
I'm not
It'll be
asking.
done. I work very well.
Just saying.
It'll be done.
It's just happened in other cases recently.
Yeah, but if that's gonna happen, we gotta adhere to these dates. This is not fair to the prosecutor.
It's gonna be,
And I know they do it. I see it. They get busy. Oh, yeah, they didn't get it done,
it'll be done.
And then the jury trial date would be,
Jess.
Off and then here, see how the motion.
Now we gotta get something scheduled. Because we can always cancel it. So we're on the 22nd of April, so you need a,
So we're changing the
The court established a detailed scheduling order. Defense motion due March 25, 2026. Motion hearing April 22nd, 2026. Jury trial May 5, 2026. The prosecutor secured 2 weeks to respond and requested paper copies delivered directly to chambers. The judge explained the inflexibility of jury trial scheduling compared to bench trials, and the defendant's bond was continued. Michigan Court Rule 2.108 governs scheduling orders and case management, authorizing courts to establish deadlines for pleadings, motions, and other filings to ensure the just, speedy, and inexpensive determination of every action. Under MCR 620 SWEM, trial courts maintain broad discretion to manage their dockets, including setting and modifying scheduling orders based on case complexity and court resources. The distinction between jury trials and bench trials is significant. The Sixth Amendment and Article I, Section 14 of the Michigan Constitution guarantee the right to jury trial in criminal cases, but defendants may waive this right under MCR 6402, which permits bench trials at any time with court approval, providing flexibility that jury trials requiring panel assembly and juror availability do not permit. Judge Johnson exercised her case management authority under Rule 2.108 to create a structured timeline that balances the defendant's right to file motions against the prosecutor's need for adequate response time and the court's interest in finality. Her explanation that jury trials are once a month and I can't move it reflects practical docket constraints, while noting that bench trials can be scheduled any other date highlights the procedural trade-off defendants face when considering waiver. The prosecutor's request for direct chamber delivery of paper copies reflects practical experience with court filing systems where documents can be delayed in clerical processing. This scheduling exchange demonstrates how case management rules directly affect case outcomes. Strict deadlines create pressure points that can determine whether defenses are fully developed or whether prosecutors have time to prepare effective responses. The judge's flexibility in accommodating the prosecutor's unavailability, switching trial dates with another case, shows how professional relationships and docket coordination affect individual defendants. For viewers, this illustrates that court scheduling is not merely administrative trivia, it shapes the strategic environment in which guilt or innocence is determined, and understanding these mechanics is essential to understanding how justice actually functions. The court denied the prosecutor's renewed motion for a competency evaluation, with Judge Johnson finding insufficient evidence that the defendant was incapable of understanding proceedings or assisting in his defense under MCL 330.2020. The court established the following schedule. Defense motion must be filed by March 25, 2026. Motion hearing set for April 22, 2026 at 9:30 a.m. Jury trial scheduled for May 5, 2026. The prosecutor received 2 weeks to respond to any filed motion and requested paper copies delivered directly to chambers. The defendant's bond was continued without modification. Judge Johnson explicitly warned that if the defense motion fails, the case will proceed immediately to trial, stating, "If you win, and there's no trial. If you don't win, you're ready to go to trial on the 5th." The defendant was advised that waiving his jury trial right could provide additional scheduling flexibility, though no decision on waiver was made. This case illustrates the fundamental tension between procedural protections designed to ensure fair trials and the system's need for efficiency and finality. The repeated delays, the prosecutor's strategic use of competency proceedings, and the judge's ultimate imposition of strict deadlines all reflect how courts must balance individual rights against institutional constraints. The defendant's insistence on particular defense strategies, despite his attorney's ethical obligations, reveals how the adversarial system depends on professional intermediaries who serve dual masters, their clients and the court itself. This case demonstrates that justice is not merely about determining guilt or innocence, but about managing competing interests within a framework of rules that shape outcomes as much as evidence does. If you found this case analysis valuable, subscribe for more educational content breaking down real courtroom proceedings and the legal principles that govern them. Check our playlist for the first section of this case, where we examine the preliminary examination and competency standards in detail. Thank you for watching, and remember, understanding your rights begins with understanding how the system actually works.